following program on Abeyratne 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the relevance and significance of construction law and the dire need for its expansion in Sri Lanka. How can our country's legislation and legal environment ensure it maintains international standards? A very good evening and thank you for taking the time to join us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Now, tonight's topic is something that I'm sure not a lot of us would have looked into specifically if we don't really need to actually delve into it, because it really doesn't concern our daily lives, but it really does speak for the infrastructure of the country and the future of the development of Sri Lanka in itself, and that's on construction and the laws surrounding it in Sri Lanka, and if we're up to international standards. But to speak on this topic, we have someone that's not a new face on the show and is very well expertised in these areas, and that is Dr. Sunil Abeyratne. Doctor, thank you very much for taking the time to come here onto the studio once again and explain this very vast topic to break it down properly for our viewers here tonight. A little bit of an introduction into Dr. Abeyratne. He is the former secretary of the Bar Association of Sri Lanka. He's a chairman for the Communication, Data Protection and Technology Committee of Law Asia. He's also the chairman currently of the ICT Law Committee of the Bar Association, as well as the ICT Lawyers Guild of Sri Lanka. So safe to say we have a lot of expertise in these areas when it comes to how we're going to tackle this subject tonight. Moving on, let's give you a little bit of a breakdown on how we're going to approach this topic. First, we'll be getting into the very basics and fundamentals. What laws exist when it comes to the construction sector in Sri Lanka? Next, we'll be going into the current context and what we need to focus on specifically to improve the quality of legal services and also the expansion of the laws in Sri Lanka when it comes to construction law. And finally, we'll be talking about the future of construction and its laws in Sri Lanka. Alright, well, without any further ado, let's get right into the discussion. We have a lot to cover, and once again, Doctor, thank you very much. Without any, pomp and pageantry, I'd like to get right into the discussion with you. First off, the most basic question. What are the key laws that we see, Doctor, right now, the laws and regulations when it comes to the governance of the construction industry in our country? And have we seen an evolution of them through these years?
And rather, our construction industry goes back to 2000 years. I think when you go to Anuradhapura and Polonnaru area, you can see how our construction industry has developed during that period. Now, anyway, that under present legal system, the mechanism, what we can see here is Construction Industry Development Act, number 33 of 2014. That's the main piece of legislation at the moment. The preamble is very clear. I'll just read the preamble. This act enacted for the development of the construction industry in Sri Lanka to regulate, register, formalize and standardize the activities of the construction industry. This is very important. To provide for the establishment of the National Advisory Council on Construction, the establishment of the Construction Industry Development Authority and the establishment of the Construction Industry Development Fund and the fund of the Construction Industry Development Authority. These are the basic requirements we can see at any developed or developing country. We can see the same concept. And to provide measures for the improvement and well-being of the industry-related professionals, manufacturers, suppliers, contractors and craftsmen, and for the settlement of dispute related to construction activities. This is important as far as the legal impact on construction industry is concerned, to ensure public safety in the construction industry of Sri Lanka. So these are the main objectives of this act. These objectives came to Sri Lanka from basically from Western countries. When you look at International Engineers Association, they have introduced the FIDIC conditions. When you look at these FIDIC conditions, we can see this requirement under construction industry. So based on that, in Sri Lanka also we have Construction Institute. They have introduced ICTAD rules relevant to construction industry. Based on this act, government has introduced, under section 2 of this act, government has introduced policies to regularize this act. When you look at policies introduced by the authorities, we can see they have made an attempt to strengthen the framework of this act. So at the moment, these are the main legal provisions relevant to construction industry in Sri Lanka.
So, as an introduction, Doctor, we see that the existing legislature, we see a little bit of backing and also improvements in policy when it comes to the construction sector in Sri Lanka. In your opinion, is there proper policy backing that's being taken place right now, or are we lagging behind?
As an international requirement, because we invite foreign investors to come to Sri Lanka and invest their money. Today, you can see, today morning also I counted how many high-rise buildings are in Colombo. When I go to the rooftop of a building, I counted 154 high-rise buildings. Earlier, we had a condominium law, and before that, we had the normal property law. But when you look at the facilities and common elements given for these high-rise buildings, we needed special legal requirements. So that is why this construction industry has developed in the world, not only with normal buildings, even you can see some factories and other constructions. You have answered your questions. Yes, we have basic legal framework. When you look at policies and the legal provisions, we can say the satisfactory situation is there, but the problem is implementation. When you come to implementation, there are lots of other issues involved in that. Especially when you come to international construction contracts, sometimes parties, stakeholders, they are not only from Sri Lanka, they are coming from various other jurisdictions. So if they come from, especially from Western countries, their culture and development of this construction industry is totally different to countries like Sri Lanka. On the other hand, when you take the Chinese construction companies, because they prefer to follow CTEC arbitration rules, and because they are familiar to that. When you take these matters, of course, we have to adjust with the provisions under the governing laws relevant to other jurisdictions. Now, how to harmonize this situation? So that is why that we need some common set of policies or procedures to deal with construction industry in Sri Lanka. If this industry is relevant only to Sri Lanka, we can have our own national policies or laws. But when you look at international contracts, construction contracts, this is mandatory. We have to maintain the international policies. That is where we stand at the moment.
All right, Doctor, now to move on with what you just mentioned, the fact that we have to not just consider the national landscape, but also the fact that, as you mentioned, the number of high-rises that you have seen counted and the number of high-rises that were constructed by foreign firms, the legal guidance of foreign firms is almost directly proportional because of just how little influence Sri Lanka's legal market has in that sector. So I'd like to ask you, Doctor, before we get to the implementation and legal services aspect, which I want to cover in the next few segments, if you could tell us policy-wise, legislature-wise, a little bit more of a delving deep into what the biggest challenges we can see when it comes to construction firms and companies as well as contractors in Sri Lanka.
Anuradhi, when you look at some websites, we can see a couple of research papers. Based on your questions, we can see these are the challenges, especially first the financial challenges there. Under financial challenges, we can see rapid changes in the national economy, inadequate support from banking sector. At the moment, banks act as giving the facilitator to give loans, but the expectation of the bank and this industry is beyond giving that facility. But they must be in a position to give some guidance and instructions, opinion, also relevant to construction industry. That is how banks in other countries are doing. In addition to that, you can see in this industry, sometimes there's a narrow profit margin involved in that. and high interest rates involved in this financial sector, and limited credit facilities we can see. In addition to that, government policy and practices. The policies and practices are relevant to Sri Lanka, sometimes totally different to another country. So this is another issue. Then bribery and corruption, also involved in that, because we are living in Asian country. Then technology. Technology, we can see lots of differences. Then management and coordination methods. In addition to that, research and development at the moment, very few people are involved in this research and development under this industry. And the resource persons, the high labor turnover, insufficient integration on design and build operations, lack of high technical construction equipment we can see. In addition to that, safety. Safety is also important. Have we taken enough safety measures in this country as far as construction industry concerned? This is another issue. In addition to that, training and development, do we have enough people to train stakeholders involved in this industry? And the social matters also involved in that, like inadequate health on construction sites. Then low level of facilities provided for workers, high environmental impact. And the final we can see the skill. Skill also very important, because this construction industry is new to Sri Lanka, though we introduced this act summer 2014. Still, my personal opinion is still we are at a very young stage as far as construction industry is concerned. So these are the main challenges. Some researchers, they have identified more than 46 challenges, including the subjects just now I mentioned. Some says there are more than 60 challenges, but on the same subtopics I mentioned. But anyway, you can see, considering socio-economic, political, cultural background of this country, there are some issues relevant to Sri Lanka, considering our culture and social economic issues. On the other hand, the main issue is sometimes if we give this mission to a contractor who are coming from foreign country, a contractor is coming from another jurisdiction, building is here, the party who placed the order also sometimes they also come from another country. So now we have to find a mechanism to bring all these three parties to a common platform and go ahead with this construction. Anyway, we can see a progress under construction industry at the moment. So we have seen 25 years, 30 years back, Anuradhi, we saw when you are traveling on road, because there are lots of abandoned buildings. But today, it's very rare. You can't see these abandoned buildings. Either they construct or they demolish. So because of this construction law, it's there. We can see there is no waste of money and energy of this country. So we can see the development here, but anyway, we have to go a long way. This
so
is the situation.
We can see that there's a streamline of sorts that we have seen gradually come into play over the past 30 years, as you mentioned, sir. But I'd like to actually touch on the area that you just mentioned, which was the safety aspect and of course the measures that we have, and also the implementation of such measures in Sri Lanka, because despite the policy, we've always as a country through our legal history had an issue with implementation. But before we take up any of those issues, I'd like to go in for a very short commercial break. You're watching Law, Land and Liberty. We'll be right back with the next segment. Welcome back to Law, Land and Liberty. We're in conversation with Dr. Sunil Abeyratne. Doctor, we just passed a very important segment when it comes to covering the basics, the foundation of what construction law is like in the current context in Sri Lanka. I'd like to continue where we left off, which is in your response, in the final response of the previous segment, you mentioned that we have, of course, the construction issues, the issues that the construction sector faces and also construction companies and firms face is is basically we have a lot of different areas that are lacking, which contribute to the fact that there's a slow growth in our construction sector right now, which is why we don't see a lot of development. And also the fact of bringing in the third party legal mechanisms and actions that have been taken by foreign contractors to build in Sri Lanka into the country. But before any of that, I'd like to ask you the most key point that I think you mentioned earlier, which is the safety aspect and also the implementation of already existing safety regulations and also legislature. If you could explain to us how much of a gap in enforcement do we see when it comes to the construction sector in Sri Lanka?
No, Anuradhi, this directly comes under legal impact on construction industry. Now take example, as you said, the safety. The safety measures directly comes under legal definition and within the legal framework. But unfortunately, when you look at this act, there are a number of committees and management committees appointed through this government mechanism according to this act. But there is no legal representation. This is very important. There must be a qualified attorney at law who is familiar to construction industry and arbitration and especially alternative dispute resolution as a member of these committees. So without having a member from legal community, I don't think that we can go ahead the affairs and the missions of this commission or management committee successfully. This is the first loophole I can see under this act. Secondly, when you take implementation part, once again, this is also directly involved in legal matter. But there once again, we can't satisfy if the safety measures apply in Sri Lanka at the moment. But there are some places we can see they have put up some boards and say that people at work and take precautions. But when you go to cities like London or Paris or Frankfurt, you can see how these contractors have taken safety measures there. Their concept is safety first. First, you must consider about the general public and sometimes who use the paths below the particular buildings. After taking all these measures only, that they can start their construction. Otherwise, they are local government bodies also, they don't allow them to start their construction. They must 100%, they must give this that assurance for the public safety. Then next is insurance. Insurance is also very important. The insurance mechanism, it's common to our country because our insurance, of course, sometimes claimants are in a difficulty to get their insurance, not only in this industry, even other subjects as well. So therefore, it's another area we have to seriously we have to look into that matter. So then architects are there, engineers are there, or most of the other professions are there, but the legal profession has no representation under these proper representation under these responsible committees set up under this construction, this act. This is what I can see. I hope that government can take immediate action to resolve this matter.
Exactly. We do actually require, because of the fact that all the aspects of constructing a building require some sort of legal expertise due to how many parties are involved as well when it comes to construction of a singular building. We see, of course, the contractor, the general public that will be affected by the construction, and of course the construction in itself. So Doctor, I'd like to move on to, I believe, a small question that I wanted to ask previously, which is relating to the construction delays and when it comes to cost overruns as well. When it comes to disputes in this area, how can we see Sri Lanka's courts adequately handling it? Do we see a proper procedure right now?
Unfortunately, construction law is not a proper subject under the curriculum of our law schools, including Sri Lanka Law College. This is as an immediate requirement we have to introduce this subject. So we can see very few lawyers in this country who can handle construction contracts. This is completely a separate subject. When you look at curriculum in other countries, mainly in India, even in Singapore, most of the Western countries, this subject is maybe optional or permanent subject. Understanding the value of the development of construction industry, they have taken these steps. So it's a high time to introduce this subject to our curriculum according to the requirement of the country, and train these lawyers, group of lawyers who are interested to involve in this industry. That is number one. With that, I hope we can resolve a lot. When you, I told you, Anuradhi, because there are more than 152 high-rise buildings here. No wonder, because more than 99% of these construction contracts have done by foreign lawyers, not by Sri Lankan lawyers. The charges are also very high. Sri Lankan lawyers have already lost their market. So that we can save this money inside this country if we train especially newcomers to the legal profession properly under this subject. From the beginning of construction, from the starting construction contract with bidding document, starting from the bidding document until test and handover, that situation, we have to pass number of steps. So when you take these, each step has some legal matter involved in that. That means if the bidding document is wrong, there will be dispute. So after bidding the project or whatever it is, there may be a number of disputes. Loser might challenge the process of the bidding situation. Then after starting of this construction, so that is why under FIDIC condition and now ICTAD rules, the resident engineer is there. This resident engineer has to play a very vital role. That is the duty of the resident engineer to give monthly report. In this monthly report, he has to give all this development of the construction of the particular project. And if the employee is not satisfied or the contractor is not satisfied, so they can bring their matters before this engineer. As a negotiator or a mediator, it's a role of the resident engineer to resolve these matters then and there. So that is how we reduce unwanted litigation before courts. Then next, they will continue. So if there is no proper solution for their minor matters, minor issues, or that disputes relevant to the particular month, then they can refer their dispute for Dispute Adjudication Board. This Dispute Adjudication Board has been set up specially to screen disputes without going to arbitration or litigation. This is very important as far as construction industry is concerned. When you sign construction contracts, you have to expect disputes. So you can't stop. But anyway, disputes also may be arise. So there must be quick response for that, and the quick solutions must be there. While that people are involved in dispute resolution, you can't stop construction. This is the most important. So then through dispute resolution board mechanism and resident engineers mechanism, we can achieve this matter. So construction is going on, they refer this matter first to resident engineer. So if there is no solution, then the aggrieved party will refer the matter before Dispute Adjudication Board. What is this Dispute Adjudication Board? This also comes under alternate dispute resolution mechanism. Who are the members who serve under this Dispute Adjudication Board? Our ICTAD rules also refer at the beginning of the construction, parties can decide the members of this board. Maybe one from contractor, another from employer, or another neutral person, likewise. So that is up to parties. Parties will decide Normal practice is employer provide 3 members, they name members of the dispute adjudication board relevant to that particular project. So then parties will go before this dispute adjudication board. So then they will try their best to resolve that. Members of this DAB will act as normally mediators. So it's a mediation. So they will try their best to negotiate and come to an amicable settlement. But this is very important. Still that aggrieved party has a right, if they are not satisfied with the decision given by dispute adjudication board, then the party can refer that matter for arbitration. Now this is where issue arises, whether we have sound arbitration mechanism in this country compared to the mechanism in other countries.
Exactly.
So then final step will be litigation. Now on that we come to arbitration, because we have Act number 11 of 1995, Arbitration Act. We have drafted this Arbitration Act following especially International Convention, UN Convention, New York Convention. So there you can see number of provisions relevant to arbitration as dispute resolution mechanism. When you look at arbitration, first of all, we must understand what is arbitration. Now, there are, we can see negotiation, mediation, conciliation, and arbitration and litigation. These are the 5 steps under dispute resolution mechanism. Other than litigation, we call other 4 steps as alternate dispute resolution. Because people who are involved in the construction industry, normally they don't like to waste their time. I have to say that waste their time or even spend their time before courts. Because they are involved in special projects, there's a limited time period is there. Now when you take this alternate dispute resolution, the expectation of the parties will be quick responses, speedy mechanism for dispute resolution. When you look at our Arbitration Act, can we achieve this? This is the biggest challenge. Now, Anadi, that after dispute adjudication board matter, as I explained to you earlier, aggrieved party can send notice of arbitration. From that point onwards, if anyone is not satisfied with the mechanism, or if anyone want to challenge not from the start notice of arbitration, we have open floodgates to go to High Court and challenge it. Appointment of arbitrators, number of arbitrators, and the appointment of the seat, that means place of arbitration. Then what is the procedure to adopt? Procedure law. And what is the substantive law relevant to arbitration? Then when you look at the inquiry procedures, maybe we expect, for the best interest of the parties, we expect due process. So someone can challenge due process also. Then it comes to the award stage under Section 25 of Arbitration Act. But with a limited scope is there to challenge arbitral award. Still that you can challenge an award if it is a local arbitration under Section 31 and 32, because 31 says enforcement, 32 says if any party want to challenge arbitral award, but that limited scope. If it is against the law or national policy, you can challenge. If it is international award, comes under Section 33 and 34. So you can see the number of occasions are there. You can go before High Court and try, because you can see a court mechanism and the time period involved in this litigation.
The fact that it's a very sensitive matter as well, because it's multiple parties working for one construction of a building.
Especially foreign parties are involved.
Exactly, and the fact that we have a little bit of a delayed system when it comes to delivering justice through the court system. I think I want to ask you as well, Doctor, specifically about the importance of ADR when it comes to the construction sector, and also to actually brainstorm with you on how exactly we're going to strategically improve Sri Lanka's legal sector when it comes to the construction aspect specifically, and also about what priorities we should have first moving forward in developing this sector. But before we get into those specifics, I'd like to take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back with the final segment. Welcome back to Law, Land and Liberty. We're in our final segment in discussion with Dr. Sunil Abeyratne. Doctor, once again, thank you very much. We covered quite a bit of construction law, specifically with the legal focus as well, and what exactly the current legal landscape in Sri Lanka can contribute to the construction sector in Sri Lanka, and how to actually communicate with international parties as well. I think on that note, we just left off on a very important segment, which is basically ensuring that we are competent enough as a country in order to facilitate the growth of the construction industry in Sri Lanka. Doctor, could you please tell us, now we spoke a little bit about alternate dispute resolution and also the importance of mediation boards when it comes to construction law specifically, and how that benefits construction in itself because of the speedy nature compared to the traditional court system. I'd like to ask you, Doctor, is that where we should be focusing our priorities on first when it comes to developing the construction sector in Sri Lanka, or is there somewhere else when it comes to a game plan in actually making ourselves competent with the rest of the key global players when it comes to construction law?
At the beginning, Anurad, I told you about the International Engineers Association's the rules, FIDIC rules. Following the FIDIC rules, we can see that we have introduced ICTAD rules. We maintain these rules at an international standard. We can't find fault with that. When you come to implementation part, of course, these are the issues that we discussed earlier, and it is specifically it comes under this dispute resolution. This is where we can see we need very speedy mechanism to resolve these matters. Resolve this matter in the sense we have to introduce, as you explained, the special mediation board. But anyway, when you look at construction contracts, we can see dispute adjudication board. In addition to that, of course, we can introduce that special arbitration mechanism even. If a person has to go to High Court and come back more than 15 times, when you look at these provisions under Arbitration Act, we have given number of occasions, more than 15 occasions, where the person can go before High Court and come back, challenging the various decisions. You see the time factor. Still, that my practical, I will explain you. There are some arbitration matters still pending before courts. This is not the delay of the court. Considering the time factor, the time we took to finish arbitration and then litigation, there are some matters that more than 12-15 years. So if it is the situation that foreign investors will not come to Sri Lanka, that's because they have enough places to invest their money. But first they will look at the dispute resolution mechanism of a country, and the finance policies and the labor laws. So these are the three factors they consider before they invest in a foreign country. So when you take finance sector, of course we encourage through BOI to foreign investors to come and invest their money. But then they will look at how this, when with the government changes, how they change the fiscal policies and their financial policies. This is also important. And whether the country maintain very rigid labor laws. This is also important. So then the other factor is dispute resolution. If there is no proper mechanism, they will not do it. What we can do is, under construction industry, so we can limit the powers of the parties to go before courts. There must be, after giving the final award, of course, there must be an opportunity to go before courts and challenge the award under limited capacity. That's a different matter. But before that, we can limit, we can close doors to go before courts. So then arbitration matter can be run smoothly. Then we can cut short the time. So this is, of course, very important as far as construction industry is concerned. Other arbitration that depend the financial sector and other areas, of course. There are also some criticism is there as far as arbitration in this country. Most important thing is legal education. This is high time to teach this subject to our law students. Then the newcomers will take this path. This very important part as far as the construction industry, the development of the country is concerned. There, newcomers can take this subject and they can take like criminal law, civil law. There's a group of lawyers who are keen to follow this subject and who are keen to involve in this area. This is, we can say it's like highway. It's like a highway. So then they can take this path, so they can improve their knowledge, they can develop their practice. This is a totally different area. With that topper, they can build their international relationship with the law firms in other countries. Now in our country, Anuradhi, in Sri Lanka, you can't give advice or you can't go before courts if you are not an attorney at law. So we maintain that situation. Even it's applied for arbitration as well. Then we can get only some opinion from another that foreign that law firm to another lawyer here. That if we want, we can get their opinion, instruction. But only a lawyer can give, attorney at law can give legal advice, or only attorneys at law can appear before courts. So then with that we can build up the network in the world. So our lawyers will get opportunity to go before another country, and they can conduct their arbitration there. But of course, that foreign arbitrators also come to Sri Lanka. We can't stop it. But in only as a representative capacity, only they can conduct arbitration here, because only attorneys at law and they are entitled to directly to conduct arbitration here. So when you look at international arbitration, the foreign lawyers, they say this is the barrier to develop international commercial arbitration in Sri Lanka. Anyway, we have to look into this matter seriously and carefully, considering the infrastructure and situation of the legal mechanism and legal system here. We can't just open gates for foreign lawyers to come here. So there will be a serious issue here. Only the solution is we must train our lawyers and bring them to international standard as far as construction contract, construction industry and the arbitration subjects are concerned.
Right. I think on that note as well, Doctor, when it comes to the importance of legal personnel that are best equipped in order to handle these issues, especially the fact that you mentioned we have attorneys at law only strictly able to present in court, which means there is a market for us to actually be able to expand the services, not just directly focusing on courts, but also on the areas that are surrounding outside the court procedure. I'd like to ask you, Doctor, specifically, since we're closing in on the final few minutes of the program as well, what we can learn from countries like Singapore and their legislature, where we see there's multiple different types of legislature when it comes to focus on construction law specifically, and also the implementation of courts. Like for example, if we can actually divert some of this flow of cases to small claim courts, or maybe to better protect contractors and also employers when it comes to the redeemable aspect, and also of course how to provide better justice to the construction sector specifically. What can we learn from countries like Singapore, Doctor?
One area is we can see now Singapore, what they say is they have the arbitration hub. Actually, my personal opinion is that Sri Lanka must be the hub. Considering the geographical location of the world map, you can see where we stand. How to do this? Of course, we can apply some speedy mechanism for it. Now, other countries, they have a number of arbitration institutions. Under arbitration institutions, they have their rules, their own rules. So likewise, we also can develop some rules, arbitration rules here. How to start arbitration, how to finish that. Now take examples, ICC rules, International Chamber of Commerce rules. These are mandatory provisions are there. Sometimes the 3 months or 6 months, they have given time limits to finish arbitration. So likewise, we also can introduce some strict rules to finish the arbitration. Now at the moment, we can't find such strict rules here, mandatory provisions. But the same, so normally even our colleagues, when they go to Singapore, they also follow the Singapore arbitration rules, and within a couple of days they finish their arbitration. Sometimes if they arbitration start on Friday, they finish that by Sunday and finish. But here we have the different culture, so we have to develop that culture first, and the attitude of our colleagues also very important. So then doing that only we can develop this arbitration as a strong dispute resolution mechanism in Sri Lanka.
Right, and on that note, Doctor, when it comes to the development of this sector and also the legal personnel in Sri Lanka, the legislature in itself is also very important. You mentioned that we have the basic necessities, but do you see, in your opinion, a future where we see reforms and amendments and also developments to the legislature in itself?
We need some, as I explained you earlier, for speedy mechanism. In addition to that, we are under development of IT sector at the moment. So we can seriously think about how to carry online dispute resolution mechanism, online mediation, online negotiation, and online arbitration. Now, online mediation is very popular at the moment. You don't need to go to arbitral tribunal. You don't need to go before courts from your office. That you can involve in dispute resolution. This is very important as far as the construction industry is concerned. Then when you take arbitration, now we have to, the most difficult area is how to select the seat of arbitration, that is place of arbitration. Under online arbitration mechanism, the parties will decide the seat of arbitration, since there is an importance when you come to enforcement mechanism concern. So other than that, everything is happening on cyberspace. But sometimes arbitrators, maybe three arbitrators or 5 arbitrators, or is it a sole arbitrator, they are coming from different jurisdictions. Parties are from totally another jurisdiction, but they will conduct their arbitration. So you can cut short your time and money. So otherwise parties have to physically, they have to travel to the destination to conduct arbitration. Here you don't need to travel. From your only difficulty is sometimes one person has to get up at midnight, another person has to 12 noon, another person will need
time zones.
Yes, time zone, considering time, so on. This is the only difficulty. Other than that, this is the easy mechanism. So this is what other countries are doing at the moment. Since we are developing IT sector, our main concept is also digital economy. This is high time to develop ODR, alternate dispute resolution, including online arbitration.
So we can see that in the future, hopefully, we'll see a little bit of a tech revolution when it comes to the legal sphere of Sri Lanka as well, specifically in order to expedite these processes and bring in such an inflow of legal expertise and the requirement of legal expertise specifically from the Sri Lankan population as well. Unfortunately, our time for this discussion has come to an end. Doctor, thank you very much for taking the time to explain to our viewers about the essential nature of developing the construction industry and its laws in Sri Lanka. Thank you very much for your time, Doctor. All right, well, we'll leave you tonight with the words of former Prime Minister of the UK, Sir Winston Churchill. We shape our buildings, thereafter they shape us. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/otherderana English. Thank you very much for watching. Have a good night.